Since 1951. This is The Legend. 105.3, 95.3, WDXE.
At Pierchoski Estate Law, all we do is estate planning and elder law. We do asset protection trusts to keep your property from being consumed by the high cost of long-term care. We do trust plans.
I recognize that voice.
Out of probate.
We were trying to get the buttons right there. Stan Pierchoski's in here, by the way. It is the Stan Pierchoski Hour. And we were expecting some introduction music there with that button, but it's actually one of your spots. Well, that's okay. We'll figure it out.
That'll work.
We'll figure it out. Good to see you, brother.
Oh, thank you. Good to see you. I do have some music that I use, and I sent it in. We'll get it figured out.
Yeah.
But
it's time for Estate Plan Stan. That's right. And by the way, the phone lines are always open for 766-9393 is the number if you want to talk with Stan. And where have you been, buddy?
Well, I think I mentioned week before last that I was last weekend.
Yes.
I was planning to fly up to Pennsylvania for my 50th. That's 50th high school class reunion.
Oh, wow. Yeah, I remember you telling that. Yeah.
And I did. I was ran into some hectic travel problems, but got to it. And it was, it's 50, so I was a little, and my class has not been very diligent on the reunions. I think the last one we had was at 30 and stuff like that. So it's been a while. And so I went, and it was actually better than I thought it would be.
Oh, that's good.
The class was about 120 or 25. I wouldn't say about 50 to 60 showed up. But, talking to the folks was kind of fun, but it was a little bit sad in spots and kind of depressing because in the beginning when they introduced everybody, they read the list of the deceased. Okay?
Yeah.
And it was about 20-some. And I knew several of them. Some of them just shocked me, just absolutely shocked me. Anyway, there was that, and there was a few other things. And there's some people that are just unrecognizable. I mean, if one for the name tags, I swear to gosh. But then there's others that you could see that it was them. They were just, had some life on them and stuff. But actually, it was kind of fun. It was like from 5 to 10 o'clock last Friday night. And I stayed the whole time. I talked to everybody that was there, even folks I didn't know that well in high school, but I recognized their name and stuff. Yeah. So it was kind of fun. It was kind of a quick trip. We kind of went in, and shortly after we came back, because that was last weekend was Saturday night or Sunday morning at 12:01 was when they were expecting the government to shut down.
Yes.
And I thought, I'm not being, air travel and air travel controllers and TSA people are all federal workers. And they're considered essential, so they have to go work even if they're not going to get paid. But,
right.
But there's a reduced number of them.
Yeah.
And the effect on air travel, I thought, I'm not getting stuck in an airport, especially in Pittsburgh, Pennsylvania.
Yeah.
So we came home Saturday, late afternoon, early evening. So it was a quick trip. Went there, did it, and pretty much came back. But it was interesting. I'm glad I did it. I'm glad I did it. So that's all.
Yeah, it's a good memory. And brought back a lot of good memories, I'm sure.
It did. And a lot of folks, everybody with health problems and stuff, kind of reminded me of what we do at Pierchoski Estate Law.
I was going to say, you're my age, your age, and I don't know how close we are in age, but anyway, it's the time to think of those kind of things.
Yeah.
And actually before, but that's what you're here for. That's what
right.
you do.
That's right. That is what we do. And speaking of which, we got another seminar coming up.
Oh, really?
You've got those. The girls plan those almost for the entire year, and I don't really know what they are too far ahead of time unless I look for them on the calendar. But the next one coming up is really 2 weeks from yesterday, Thursday, October the 19th. And like I said, I think it works out to be 2 weeks. And it's going to be over in Pulaski, right on the square, at the Star Theater, which is right next to my office. If you need the physical address of that, it's 105 North First Street in Pulaski. And because it's on a Thursday, we do that at 1 o'clock in the afternoon. So October the 19th, 1 o'clock, we call it Will's Trust in the Nursing Home. And that's what we talk about. It's a good hour to an hour and 10 or 15 minutes long.
Yeah.
And we have a question and answer period afterward that usually is very extended. I mean, we're there I'm almost always there for at least an hour to an hour and a half afterward answering questions. And I'm happy to do it. It's actually my favorite part of the seminar, to be honest with you. So, if you have questions, you can, bring them with you. If you develop any during the seminar, just write them down. And at the end, we will, I don't want anybody to leave the seminar with a question unanswered. So, like I said, I encourage that.
That's not that far away. October the 19th. That's not far away.
2 weeks from yesterday.
And it's preferable if you register for that event.
Well, we ask people to RSVP, but it's really not that formal. We just like to have a head count for a couple of reasons. One, I like to put out enough tables and chairs.
Can we call your office to do that?
Yeah, you can call me at 931-363-7222 and talk to one of the girls and just tell them you're going to come, and basically how many you're coming with you.
Absolutely.
But if you can't commit, and then Thursday morning you say, okay, I think we can go, just come on and walk in. We put up extra, but
Sure.
I just don't like scrambling at the last minute, rolling out some more tables and chairs. We just want to have an idea. And of course, a couple of the gals make light refreshments, and it's like the worst thing that could happen when they make refreshments and there's not enough.
Yeah.
That's like the end of the world to
Yeah.
the women that do that. So we don't want that to happen either. So show up with, it's not a meal or anything, but some light refreshments, but just
Sure.
just something to have. So yeah, I'll talk about that again at the end of the hour. So we have those that come up. We now do that in 6 counties.
Yeah.
So next time we come around to Pulaski or here to Lawrence County, I don't know. We tend to do Giles and Lawrence a little more often.
Mm-hmm.
They're nice big venues. They're usually available. Some places when you rent a place, it's got quite a backlog. And I know they rent the place over here in the back in the country kitchen, but
Right.
It's not. They don't have that kind of calendar there. So it's not too hard to find a day to squeeze in. Same thing with the theater.
Yeah.
You just got to work around what's going on at the theater, which is a lot. And if I remember to mention it at the end, I will. So
Yeah, absolutely.
But yeah, so we talked on this show. This is we call it bulletproof estate planning. We talk about estate planning topics, which there are many topics under this heading. So if you do have a question, we do encourage it. When the WDXE over here and WLX decided to go change this radio station to a talk radio.
Yes.
Well, I looked at that and I thought, this would be a perfect opportunity to create a kind of show where people can call in.
Yeah.
So then that's what we encourage. So if you have a question, it doesn't necessarily have to be about the topic I'm talking about on that particular Friday. Anything that you heard me talk about before, or just have a question of, just throw it out there, and we'll be glad to give you an answer for it. So one thing I want to start off with is, I keep track of things that happen in the courts, and it's not real popular that things happen in estate planning in the courts, but every now and then it does.
Yes.
And surprisingly, this one case came out of a different state, but it was surprising to me because it really fits this day and time. And that is, there was when I talk about wills, and if you listen to me talk at all on these shows or my show out in Nashville or at my seminar, you're going to determine real quickly that I'm not a big fan of wills for a couple of reasons. Wills are very formally executed, and they go through probate, and there's a lot of rules and I dotting and T crossing to get your will right. So. And I sometimes people don't believe that when I tell them. And so I keep, when I find these will challenges that go through the courts, I bring them up and I bring them to folks to let you know exactly what the courts say about this. And what the courts say is this: they say the legislature has the authority to govern by statute what it takes to make a valid will. And they said, but we are going to construe those statutes very strictly. And if you remember, maybe a month or two ago, I brought a case where the person didn't sign the signature line on the last page of the will, but did sign the next page, which was a affidavit of the attesting witnesses.
Yes.
And they said that the statute said he has to sign the document, and that last page was not the same document as the will, because the will was labeled page 11 of 11, and it was the end. And they said, it's clear what the intent was. It's clear the guy meant to sign the thing, right?
Yes.
I mean, it was done in a lawyer's office, and how that slipped through blows my mind. But,
Yes.
But it slipped through. It's clear he was there, he signed his will. It just didn't get done. They say strict construction. It was not signed, and the will is invalid.
Wow.
So this case I'm going to talk about was out of another state, but it made me think about going and looking at our laws.
Yes.
And it was somebody was sick, and I think it was even back in near or post COVID.
Okay.
And an attorney again drafted a will for them, and they e-signed it.
Oh.
Kind of like DocuSign.
Yes.
Okay.
Familiar with that.
And a couple of years later, she passed away, and when the family went to publish the will for probate, the court rejected it and said that's not a signature. Well, they ran it up on appeal, and the appellate court, I think it was for Pennsylvania, really, so that state said, they did the same thing. They said no. They actually have some modifications to those laws in that state that said during the pandemic and all that stuff, you can do this and you can do that. You can do things remotely and stuff. But they say they specifically excluded last will and testament.
Oh, wow. Okay.
And so, they went through a whole long dissertation, but the bottom line was it was not signed because that's not a valid signature on that particular document.
Yes.
And I looked at our laws and stuff, and we're kind of the same, but because we have not authorized e-signing. Now, let me just make it clear that when I talk about e-sign, I'm talking about something like you see called DocuSign. I think DocuSign is a trade name, but
DocuSign,
where
Loop.
Yeah, where you kind of make an electronic signature.
Right.
You don't physically sign it. Now, that's different than some of the stuff you may see, and we can do this too. What we call remote online.
Yes.
I got 2 notaries in my office. One, we've gone an extra step and got them qualified for what we call remote online notary. What that means is we got somebody that's bedridden or a lot of distance between us. We can send them the documents in the mail.
Yes.
Then one day we call them up and put them on Zoom or FaceTime or something where we have a video communication, audio visual. We can see them. And we have to go through certain steps. They have to identify themselves, hold their driver's license up. They have to position the camera so that we can see them and see the document that they're signing. And they hold the document up, and then we talk about the document, and then they lay the document down. This is on the camera, and we see them sign it. Okay, and so they sign the document, and you can do this with the will too. And they sign it. Then, when we're all done, they mail it back to us, and we get the document back. The notary can stamp it, and the witnesses can sign it, and they can date it the day that we did the video conference. So let's say, we do the video thing on Monday. They mail it back to us. It gets to us Wednesday or Thursday. Let's say we can notarize it and witness it with our signature.
That's interesting.
But the language says we're doing it as of Monday when we did it. Now, what we're doing there is that's actual signature as opposed to an e-sign. The person actually signed the document.
That's correct.
The only thing that they're allowing a little bit of lax in is, when you have witnesses and stuff, it's supposed to be in the sight and the presence of each other.
Yes.
And so they're extending the sight and presence to the video conferencing.
Yes.
As long as you follow certain controls and make sure that that's
now, is that established here in this state as well?
Now that
is established here.
That is allowed. That's allowed. But it is not an e-sign. Again, don't make the mistake of an e-sign. You never actually sign the document. You have this pre-imaged signature that's digital.
Yes.
And you attach it.
Now we use that quite often with contracts, and real estate documents,
and there's nothing wrong with e-sign. They use it a lot. Right. I'm strictly talking about the statute doesn't allow it for a last will and testament. And again, you're usually looking at the document online. When we do the remote online notary, they have the document in front of them, and their pencil and their pen is on that document making the signature. So that's the difference. Sounds like it might be subtle, but it's really kind of a big difference. But so we can do that. But so if you do a will, a lot of people like to do it yourself stuff for LegalZoom. If you do something and you do an e-signature, I'm telling you right now that may not fly when it's time for it to work. And that's the last thing a family wants. Okay, you're deceased, they are probating your will, and the court says, sorry, this is not a will. I mean, that's not the time for a mistake like that to surface, because it's just there's no recovery from that. If you have a will and you've done that, you can recover. You can just do another one and sign it. It can be the exact same language and just sign it this time. Yeah. And you have to sign. Again, several weeks ago, we went over the validity of a will. And a valid will simply needs to be witnessed by 2 people.
Yeah.
I mean, our statutes, he's pretty lax. It doesn't even say they have to be independent witnesses.
Yeah.
Now, I think it's a good idea that they're independent and uninterested. In other words, technically, I guess if you have 2 children and you're leaving everything to those 2 children, they could be the witnesses. Because the statute just says 2 witnesses and that's the minimum.
Yeah.
I think it's a good idea as somebody that's not part of and doesn't take under the estate. It's a better witnessing when it's an independent person. And that's what we do in my office. We bring people in that just are available when I need them, and they don't know the people, or they might know them, but they have nothing to do with the estate. They don't get anything out of it. They don't have a dog in that fight, and that's what you really need. So, but that's all it needs to have done. I've heard this so many times. Somebody come in with a piece of paper and they'll say, "My dad wrote this out and he notarized it and everything." It's like, yeah, that's great, but notary is not what it requires. It requires witnessing. To be a valid will.
Right.
Now, there is a document that gets notarized. There's a document which in the other case I told you, the gentleman signed that, but not the actual will. There is a self-proving affidavit of the 2 witnesses that gets notarized.
Okay.
And all that is some statements. An affidavit is a sworn statement. And the 2 witnesses are swearing that certain things happened. And the certain things that happened are we're all in the same room, we're all in the sight and presence of each other. I signed it in the sight and presence of the testator as well as the other witness. The other witness says the same thing. It's all, he purported in our presence to be of sound mind and stuff like that.
Yes.
So if we have this self-proving affidavit, so if 20 years later somebody's challenging his will and they need to get the witnesses to testify what happened that day,
Yeah.
and we're gone or can't be found or MIA or dead, they can, instead of bringing us in to ask us these 5 questions, they can bring in the self-proving affidavit, which is a sworn statement that we, in other words, we're already testifying in court at the signing of the will as to what happened that day. So 20 years later, if they want to contest it and ask us what happened that day, we've signed a sworn affidavit stating what happened that day.
And this comes into play mostly if the will is challenged, or
typically only if it's challenged. You do not have to have a self-proving affidavit. It is a really, really good idea.
Okay. All right.
And I think I talked about a case where somebody didn't have one.
Yeah.
And they had to bring the witnesses. You have to prove the will. And you got to prove the witnesses.
Okay.
They got one to come in and testify. They could not find the other. And the appellate court said, no dice. We are going to strictly construe this. And the statute says, under the proof of 2 witnesses, and you can't prove both witnesses because. And they even said if you'd had a self-proving affidavit, you'd have been in good shape.
Yeah.
But it wasn't, and it failed. And that's why I'm not a big fan of wills. They are strict, formally executed, hyper-technical. There's no doubt about it. They're hyper-technical. So if you do a will and you're a do-it-yourselfer and you get one thing wrong, I'm going to tell you right now, the courts will not uphold it. They say in the front, we're going to go to the statute and we're going to strictly construe the requirements of the statute. And I get it. I know why they do that, because you're dealing with a situation where the person that wrote it's not here. So you have to try to determine their intent.
Yes.
And they're gone.
Yeah.
And that's a very tough row to hoe sometimes. And if you can't determine what their intent is, then they're going to throw it out. Because everything, it's so easy to manipulate property and stuff like that when the person that's leaving it is not there to defend what they meant when they said in their will. So when you write a will, and you just don't want it to be like a letter to Aunt Gertrude sometimes. You want it to be a little more...
You're dealing with legal issues.
Spell it out.
Just as something as simple as yesterday, we're trying to get my daughter's driver's permit.
Okay.
Okay, she's 15.
Okay, you're at that stage.
Gotcha. So she's chomping at the bit to go.
Oh, yeah.
She got her test done online, all that kind of stuff. And so we show up there, and I've got her Social Security card. I've got the stuff, but there was some stuff asked for that I wasn't sure why they asked for it, or or where we would get it. So, but sure enough, we get there, and no dice. We have to have a document from her school, which she homeschools, but we can get that. We have to have her birth certificate, Social Security number, and then, of course, I'm the responsible party. So all these things have to be done, and I'm going, but can't you see? She's right here. She's 15. She's a citizen. She's my daughter. So, but they won't take my word for it. You have to back it up with documents.
You hit the nail right on the head. We do a lot of that when we qualify people for TennCare.
Yeah.
Okay. We fill out the TennCare application, okay, and you send it in, and it's like, okay, this is Miss Jones, okay?
Yeah.
Her husband was Mr. Jones, and he passed away 11 years ago, and she's single,
Yeah.
And stuff like that. And they're going to say, I mean, they don't say this, but this is how it works. It's kind of like, well, that's great, and we appreciate it, but we really don't want to take your word for it. We'd like to see a marriage certificate.
Yeah.
We'd like to see your deceased husband's death certificate.
Yeah.
And then all this identity documents, and you feel like this is ridiculous, But
it does make you feel that way.
I guess you can put yourself in their shoes, but still, like I said, then you saying it, when you get to the government and you get the law sometimes, you saying it doesn't always make it so.
Yeah.
The only time you saying it means anything is if you're in a witness stand under oath, right?
Right.
And you have the ability to be cross-examined. So they just, they want to know for themselves that what is on this application is correct.
Right.
Because things are different if you're married or if you're single. And also they want to know about the deceased spouse, because then they go and look to see if he owed TennCare any money.
It has to be
every
verified.
time. Yeah. And so it's exactly like you said. I mean, what you can do ahead of time, if you think of it, is a good example is, there's new IDs you get, you call them what do they call it? The star, with the star on it, or the heart.
Oh, really? I'm not aware of those.
The real ID. That's what it is.
The real ID. I'll have to look that up.
2 or 3 years ago, it was like in 2020, you could never travel unless you had what's called the real ID. And so driver's license with a star on it. And it just required you to go in there and get one with some documentation.
Yes.
And they gave, anyway, when COVID come, they said, they punted it out a couple of years. And now it's back. And now they have a deadline. I don't know what it is, because I got one way back when. But they give you a list of paper and they say you can show up with, I can't even remember what it is, but it's something like Category A and Category B. So you can show up with any 3 of the documents in Category A, or any 2 of the ones in column B and 2 in the column C, or something like that. And they list all these different documents. Yeah. So it's good to know if you have that before you go there, and especially if you go to the DMV and you take a number and you're there for a while.
Right.
You might want to have all the ducks in a row before you get there.
That's
you know
right.
what I mean? And you can attest to that, to be at the DMV. So sometimes if you can think of it and you can get the requirements that you need before you go there, then you can be kind of prepared for it. And imagine if you had all that, it had gone pretty smooth.
Yeah. Oh, yeah. It'd been just fine.
Now it's a whole other trip.
Nah, a whole nother trip.
And does that?
Which it's okay because we're kind of dragging our feet about putting her behind the wheel anyway.
I was going to say the delay is a little self-serving, but
we're okay with that.
But I get it. I'll never forget the time my daughter got her permit and she made her first solo run. Yeah, we see her driving down.
Kind
the
of
driveway.
draws you in a knot, doesn't it?
My wife and I are watching her drive down the driveway and thinking, "Oh boy, I sure hope the phone doesn't ring." No, yeah, but. And I mean, I get it and understand it. So anyway, that's when I was talking about wills, and they're hyper technical. You can still do a will, but you probably ought to have an attorney do it, and you really ought to have an understanding about what makes it valid, because it seems like sometimes it slips through from the stuff that I read. But a better option is the trust, and it's a better because, I mean, it's not as formally executed. That doesn't make it any less legal. It's kind of it's governed by a whole separate set of laws, and so it just works different. It still, it still is 100% enforceable. It's actually more enforceable than the will. It's less challengeable than a will, stuff like that. And we deal with that kind of stuff all the time in planning, whether it's TennCare planning or just foundational planning. We even have a will in our trust packages. There's a certain kind of will that's nice to have, because when you have a trust. You've heard me talk about it before. You want to fund property into the trust, because if it's in the trust, then the trust controls where it goes. And if the trust controls where it goes, then the trust can keep it out of probate.
Yes.
But it's got to be in the trust. Back in the 90s, they used to have these trust mills would come through town. They come out of someplace in Kentucky, and they go from town to town. And they hold a 2-hour seminar, and they help you write a trust. At the end of the day, they say, congratulations, you have a trust, good job. They move on to the next town. And what I've seen years afterward, people say, great, I got a trust. They take it home, they put it on the shelf. Uh-huh. They're not told, they're not coached, they're not advised that now you've made your trust. Think of it as a box. I draw a box on my whiteboard and say, here's your trust. But now it's empty. We made it, but there's nothing in it. Yeah. And it can't be because we just made it, right? Yeah. So we have this empty box. Now, what we want to do is put property in the box. So we got to go get the property redeeded. We talked about that one week. We got to go to the bank and say, hey, I got one of Mr. Stan's trusts. I want to change the ownership from me, the individual, to me, the trustee, and put it in the box. Right. And there's a handful of things you have to do for that. Some of the things when I do trust, I'll do for you. But these people were never advised that. Then decades later, they pass away. Their kids bring me the trust, and we find that there's nothing in it. It's empty because they were just never told to go fund it. So, the trust works differently. Okay, but we want to get property in there because the whole idea is to avoid probate. It only avoids probate if you put the property in. Yeah, because the trust can only govern itself.
To put it in maybe layman's terms, your property, the ownership of it, has to be transferred to the trust.
That's right.
You own it, but the ownership has to be transferred to the trust.
That's right. And a good way to do that.
My son is being dropped off to me. I'm sorry.
It's all right.
Dan, go ahead and have a seat over there, bud.
When you put it in the trust, there's really no such thing as in the trust, because the trust is a legal fiction, so it really can't hold property. What we do is we vest the property with the trustee. So let's take a deed, for example. It's a good thing to use as an example because you could look at one and see what happened, really.
Yes.
So I'm sitting here holding the deed, and let's say, I got some property out there towards Campbellsville in the north west corner of Giles County. And, let's say the deed says Stan Pierchoski. The grantor is John Doe, who guy that sold me the property, right? Right. Warranty deed, grantee is me, Stan Pierchoski. And so I say, I'm going to put this in my trust. So I get a new deed where the grantor now is Stan Pierchoski. And it's a quitclaim deed, which is, it's not a general warranty. It's just more of a reassignment of ownership is what a quitclaim deed is. Right. But it is a conveyance of property. And now the new grantor, the new owner, is going to be Stan Pierchoski, trustee of the Pierchoski Living Trust. Yes. So now it's in the trust because the property is vested with the trustee.
Yes.
That's what in the trust means.
Right. That's
So same thing with a bank account. You go on a bank account, you say,
Yeah.
hey, I have this bank account. Can I change the ownership from me, the individual, to me, the trustee? And the bank will do that.
Yeah.
You sign a few pieces of document. They just change the ownership.
And we've talked about this before, but it's one of those things that can slip your mind and not get done.
Yeah, and so it's called funding the trust. It
Right.
doesn't cost you any money. The funding just means you're moving it from outside the trust to inside the trust.
Right.
And we take that very seriously. Alex in the office is my funding coordinator, and she follows up with people and says, how's the funding going?
Have you got this done?
Here's the position I take. I put everything into the trust that I can put in for you. So let's say if you were in my office doing a trust, at the signing, I would have all your deeds prepared for you,
Yes.
you and your wife.
Yes.
And we would put those in that very day. I also prepared some documentation that puts in your personal property, your stuff,
Right.
your untitled property, your pots, your pans, your tables, your chairs.
Yeah.
And as of 2012, your vehicles and your boats.
Okay.
Not airplanes now. You still got to retitle airplanes.
Oh, okay.
But
That messes me up.
all your stuff, okay? Yeah. All your stuff we put, and I'll put that in for you. What I can't put in for you is the other category now you have other personal property, but you have a contract with a third party, which usually is in the nature of a financial institution, like a bank,
Okay.
investment, Vanguard, Fidelity, stuff like
Sure.
that. And so you have a contract with them, so I can't put it in. If I go to the bank and say, hey, I want to put Jeff's bank account in the trust for me. I mean, they're going to show me the door because I don't have the authority to do any of that.
Right.
But what we do, and so I can't put that in for you. So I have to rely on you to do it. But what we do in my office is we create the documentation that the bank is going to want to ask for. We talk at length as to how that visit's going to go. I sit down and say, okay, I can't put this in for you. I would if I could, but I can't. But here's how you do it. You go to the bank. And if you need me, I'm available with a phone call. If you need me to hold your hand and walk into the bank with you, I'll do it. Because it's that important to get everything into it. So,
Yes.
But it really goes very smooth. It goes very smooth.
Yeah.
But you go to the bank and you say, hey, I didn't want Mr. Stan's trust, and I want to put my bank account in the trust.
Yeah.
I mean, banks are no strangers to trust law. Every bank has a trust department. They know how it works. But they're going to want a couple of things. They're going to want to be able to prove there really is a trust.
Yes.
So think about it. The bank is like, well, we don't want to make an account in the name of a trust if there isn't one.
Right.
Now, why anybody would open up a bank account in the name of a trust when the trust didn't exist, I don't get. But the bank's considered a vehicle of abuse, and I understand. So you need to prove to them that the trust exists. Now,
Okay.
the next question that comes up is like, well, gee, do I have to show them my trust because it may have a bunch of personal information in there.
Yes.
What if it has in there, I got this drug addicted child, and the way I leave him is inheritance. Is all kind of ways to help him if something happens, and I really don't want to bank reading that, right? So our legislature created a statute which says, okay, you're not allowed to see the whole trust, but you are allowed 5 pieces of information to prove it exists. The name of the trust, the date of the trust, who the original trustor was, who the original trustee is, and who the successor trustees are by name only. Those 5 things. And they created a thing called a certificate of trust. And that, too, is an affidavit that the trustee signs and has all that information in it. And so the bank, it really doesn't go through all that. The bank's just going to say, yeah, we'll do that. Do you have a certificate of trust? And
that's
say,
it.
Sure, here it is right here. It's in the book. And you give it to them. They'll make a copy of it. They'll give it back to you. And they'll be happy as a clam at high tide. That's what they need.
There
Because
you go.
the statute says any organization or person or entity that needs to prove the existence thereof can rely on the information in the certificate of trust. Now, what that does for the bank is they really don't want to see how you leave it to your kids. They just want to make sure the trust exists. And so it's liability, okay?
Yes.
And so if they put all your money in trust doesn't exist, and then somebody comes in and says, well, where's my money? And say, well, we put it in this trust, and why'd you do that? Because there was no trust. It's a vehicle for abuse. And this just gives them the opportunity to feel the warm, fuzzy feeling that there really is a trust, so we change your account over. But it's real routine. So you don't go through all this. I'm just explaining what's happening. When they say, do you have a certificate of trust, and you hand it to them, that's what's all happening behind that.
That's what's happening.
You are proving to them that it actually exists without disclosing any personal information. And now once you do that, all the property's in there. So I was saying that Alex is our funding coordinator. She usually follows up and says, have you got your bank accounts in the trust yet?
Mm-hmm.
And if the answer is like, well, it's busy, and the kids are at soccer and it's like, okay, well, she calls you again in about 30 days.
Yeah.
Okay. And
you got to get this done.
And again, if it's like, well, I've been busy, and my back's been hurting. And she's going to say, well, you know what? I'll call you again in 30 days, but pretty soon this is going to bubble up and end up on Mr. Stan's desk. And he's going to call you because we take this very seriously. And he's going to tell you something like, listen, if your bank account is not in the trust, it's not in the trust. It may have to go through probate all by itself if something happens to you. And probate's the whole thing we're trying to avoid. So it's important to it's easy to put in. And, usually I've made those calls, and I'll just say, look, what's the holdup? Is there anything we can do to help? I mean, I'll be glad to do it because we really want to get everything in there. We don't want to delay.
Right.
And usually it's just procrastination and stuff.
Which I'm very good at, by the way.
And everybody is, me included. The only thing I've gotten good at is realizing when I'm doing it, when I'm procrastinating.
Yeah, I'm good at that too.
But so we have a process to get in. And usually, once I explain to folks, look, this really is pretty simple. When you go to the bank, it goes very smooth.
Yeah.
You don't get they don't give you any hassle. I mean, every once in a great while, a bank will be a little confused as to what we're doing. And usually every single time that happens, we're talking to the wrong person.
Well, either that or maybe somebody new who hadn't experienced it before at the
That's
bank.
exactly
some
it.
kind of thing.
Like I say, we're talking to the wrong person. They don't get it,
Yeah. I had a quick question regarding that. So most of what I think, I'm guessing, that would be put into a trust as far as bank accounts, it would be considered investment accounts, or or is it all your accounts?
Well, when you're dealing with a revocable living trust, which is not the asset protection trust, it's everything. It's the checking account, the ones you use on a daily basis. And everything. There's no downside to it. Once you put it in there, and that's a good question because I often get asked, okay, if I put my bank account into the trust, do I have to change my checks and all that stuff? And does the number of the account change and all these ACH withdrawals that I have every month that I've set up, are they all... Yeah. Kind of like when your credit card gets compromised, they send you a new card. Yeah. Pretty soon you're going to get a call or an email from somebody saying, hey, we tried to run this card on this automatic payment. It didn't work because it doesn't exist anymore. And it's not like that. You keep the same account. All banks will do this. You keep the exact same account. The number's the same. They just change the ownership.
Oh, okay.
Now, people say, do I have to change my check? Because in the upper left-hand corner of your check, it says Jeff Hood. And it's like, okay, do I now have to get new checks that say Jeff Hood, trustee of the Jeff Hood Living Trust, dated October 4th, 2023?
Right.
And any amendments thereof? Okay, and the answer is no. Yeah. Now, if you did that, it would not be wrong. But there's no reason to do that because the bank knows who owns the account, right? Sure. So I tell people, don't do that because you might go to a local store, they look at that and say, well, I don't know if I want to take that check. What's all that about? It's a lot of language. And it doesn't have to be on the check. Sure. If you did change it, it would be okay.
And less checks are even being used.
True. So, so it's real seamless to you. Yeah. So people say, well, how do I pay if I have a checking account, I pay the light bill, I pay I pay the garbage bill, I pay the rent. Yes. After I put my bank account in the trust, how do I do all that? Right. The answer is the same way. You write a check on the exact same account, the exact same checkbook, exactly like you did before it was in the trust. It is seamless to you. And nobody knows it's in the trust, and nobody would care anyway. But the bank knows that this account is now titled in the name of the trustee, which puts it in the trust. Now, when you ask the question about do we put it all in, and the answer in that kind of trust, yes. But when we deal with our asset protection trust, like the one for avoiding the high cost of long-term care, the answer is no. We don't put in the stuff we live off of on a daily basis. It gets cumbersome because this is the kind of trust where once you put stuff in it, it kind of stays there, and it's difficult if it changes all the time. Sure. We protect that another way, not with the trust. So, but when it comes to funding, now this is a really important point. If you have an asset protection trust, you want to avoid the high cost of long-term care. Okay. It is really important to get the assets you don't want to lose into that trust because that's the asset that gets protected in an asset protection trust. Right. If it's not there, it is not protected. Because the trust is a legal entity. Yeah. And it can protect or control or do whatever you want with the property that's in the trust. So if it's not in the trust can't reach to it. Okay. That's what makes it work.
Got a question through the text message.
You did?
Yeah, they didn't want to call in, but they text me with a question. How about that?
Did they text your personal text?
Text me, yeah.
Oh, okay,
yeah,
cool.
Yes. Didn't want to be on the air. Question, it says. It says, I have a Class 3 trust. Can other items besides Class 3 items be added into that? I don't know. I haven't heard you mention a class. I don't know what that is.
That's confusing to me too. The only time the Class 3 rings a bell to me is when you talk about something called a gun trust.
Okay.
So maybe they can clarify that and send in and say, is it referring to a gun trust? Because there you have different classes of weapons.
Okay.
And a gun trust is a way to own property or own firearms or stuff that you can't normally.
He says
own.
correct.
The gun trust. Okay. Let me take a stab at it. But I don't do gun trusts, and I don't do them for a couple specific reasons. One, the laws on that change often.
Okay.
It can be damaging if they're not done right. Here's an example. A gun trust, in its general terms, is a way to own like these, and I don't even know the classes. I mean, I have guns, but I don't have those kind of guns.
Yeah, right? There's some guns that are in different categories.
Like, grenade launcher or automatic weapon or silencers, I think, stuff like that. Yeah, things there's certain things that you can only own if you own them, if your gun trust owns them.
Yes.
And what I have heard happens is that some people will say in their trust or their will, I'm leaving all my guns to my son. Well, when you own guns in a gun trust, you're in legal possession of something that's not legal for you to possess. I mean, you can own it, but you have to own it that way because of the class of gun it is. And sometimes if you just say, I leave all these, guns to my kid, when he inherits them, he's like suddenly in illegal possession of some stuff because he doesn't have a gun trust. You see what I mean?
Oh, okay.
And I've heard of that happen, and I've heard that the feds, when that happens, are pretty relentless on prosecuting that, and they're pretty merciless. I mean, they just say, hey, it's not legally owned. But there's a way to fix that. But I've never ventured into that, and one of the reasons is I deal with a lot of people with guns, and guns are personal property.
Well,
and you can leave them
to
the heirs. Because I'm talking about your regular handguns, your rifles, shotguns, stuff like that. I mean,
sure.
Regular. I think those are Class 1 guns. No special ownership necessary. Registration and stuff, of course, that sort of thing. But no special ownership. Now, when you have something that is a Class 2 or 3, I think it is, that needs to be in a gun trust to own it. I know somebody that does almost exclusively gun trust, and I usually refer to that person because they keep up with it all the time.
Oh, okay.
It's a tricky.
So you have resources.
Yeah, it's a tricky area of trust law, and I'm sorry I can't answer the actual question about the different kind of classes. It's kind of like my wife always says, that I'm a little out of my lane on that, and I don't like to get out of my lane, and I don't want to give you legal advice. But if you would call me or email me, or go to my website and get my email and email me, I will refer you to somebody that I'm very confident could answer that question.
Okay.
Because they deal with gun trust. Now, and gun trust has nothing to do with Tennessee law.
Yes.
That's preempted by the feds. Most of it.
Yes.
So it's kind of the same everywhere.
Okay.
So I think this person I referred to, I'm pretty sure if I remember right, is in Florida anyway.
Okay.
But and I've referred many folks to them. They do they do gun trusts for them. So that is just a specialty.
Is that the? It's the only one I can think of anyway. Is that the only kind of specialized trust there are? Are there other specialized trusts?
The other specialized trusts that I don't really get involved in is there are IRS kind of trusts for tax avoidance things that are really odd, or kind of things that your relatively wealthy folks do to avoid.
So
tax
if I win the lottery,
property.
the current lottery,
well.
At 1.4 billion, I may need to talk about that.
I mean, when it really needs, people with a lot of wealth deal with those and it's really kind of strange because you pretty much divest or divorce yourself of all ownership to get the tax break.
Yeah.
Which, to me, is like, well, big deal. If you're not going to own it, you don't get the tax. But they want to keep stuff in the family somehow. They don't want to lose complete control of it, but they don't want to be taxed on it either.
Right.
Because some of that very expensive stuff or very valuable stuff carries a heavy tax with it.
Yeah.
So I don't deal with that. I mean, we deal with this fundamental planning and descent and distribution planning, meaning distributing property after death is a short way of saying it. That's what we deal with. We do it, and basically I only deal with about 3 or 4 different kinds of trusts on a routine basis.
Yeah.
We do the revocable living trust, we do the asset protection trust, we do what's called special needs trust when you have a child that's got special needs and is on a disability.
Okay.
And we don't want them to get an inheritance and then make them ineligible for their disability.
Yes.
So special needs trust, and I actually do some domestic asset protection trust not too many of those. Those are pretty rare.
Okay.
Those are the kind of trusts you can do in Tennessee that you used to have to go take to an offshore jurisdiction.
Yeah, we may be getting a question. Let's see if we are. Hey, good morning. You're on with us in Stan Pierchoski.
Yes, this is Wayne Richardson. I'm driving at the moment, but I was listening to your program with Mr. Pierchoski, and we are clients of his, and I just want to give an on-air compliment and recommendation for him to everyone that's listening, because he did an excellent job for my wife and I in setting up our trust.
Awesome.
Well, thank you for those humble words, Wayne. I
Hey.
appreciate it.
Well, good deal. Well, I appreciate it. And he does, too, if you can't hear him, so thank you.
Yes, sir. Thank you.
All right. Well, very good.
I mean, so he couldn't hear me on the phone when I talk, right?
He can. I don't know if he could hear you then, but I know he can hear you now.
Gotcha. Yeah. No, Wayne, thank you very much for the those are humbling words. I mean, I thank you for those kind words. That does humble me. That makes me feel wonderful, because that's. I mean, it's hard to explain, but I really like what I do.
Yeah.
I mean.
Yeah.
I'm kind of of retirement age and probably should. I kind of have a plan, but I'm going to do this for a while. I really like going to work every day and do what I do. It's different for everybody.
Yeah.
It's challenging to me. I just like doing it. And I like having a relationship with my clients. I used to practice a lot of criminal defense work. That wasn't there.
That wasn't fun.
Like I often say, I get thank you notes from my trust clients these days, or like this comment from this gentleman. And I didn't get any of that when I used to do it before. I mean, somebody get a thank you, you get somebody out of jail, but in the grand scheme of things, what was I really doing? So I've been doing this for some years now.
Well, that's rewarding.
It is rewarding.
There you go.
It is rewarding. Yeah. It's a wonderful feeling when you get that kind of feedback from folks, and that's what I try to do. And if something ever isn't quite right, we really bend over backwards to try to make it right. Yeah. And that, things like that happen from time to time. We had a good example was, we proofread stuff, and we proofread it, and we proofread it. Sometimes you feel like your eyes are bleeding. You know what I mean? And still, with all that, I think it was the week before last or something, we published a deed. And there was a person's name in there. We had put a reference to a deceased spouse.
Yes.
His name was Jack. And in the same sentence, and this missed all the proofreading, which I just don't get, but as hard as we try. In one sentence, his name was Jack, which is correct. In the next sentence, his name was Jake. And it's like, when that came to our attention, we thought, how the heck did that get by all our levels of proofreading? And it's like, I'm one of the levels of proofreading, right? I'm the last level of proofreading, and I didn't catch it. So stuff happens when it does. And now that's a non-fatal error. I mean, we could have done nothing. Yeah. But it's just like, what, let's just do it right. And so we can do something that's like a Rule 60 clerical error with a deed and say, look, there's no material change here. It's obvious what it should have been.
Yes.
And so we just change it to the right name. But, we like I said, we really, it's really client and customer oriented is what we like to do, because, when they're going to deal with this trust someday, and it's going to have to work for them or for their children, right? It's going to happen. And I don't do the kind of work where I'm worried about the children coming to me and saying, "Hey, this thing doesn't work." Like, remember I said earlier in the program, when these trust bills would go by, and their kids come to me with a trust and say, "Hey, Mom, Dad, I had a trust. What do we do?" Yeah. I said, "Great, they have a trust. This is going to go real smooth." Lo and behold, we look into it, and there's nothing in it. We get their bank account still titled to them. We go to the deed; it's still titled to them. Yeah. That's not happening with me. I'm not going to tolerate that. I mean, this when you put the property in a trust, like you're supposed to, which is why I say we take the funding so seriously. If you fund a trust the way we're supposed to, it is a well-oiled machine at the time of death, and your heirs go through. I've had people come in and say, "Man, my best clients are this." People come in and say, "Hey, Mom and Dad had a trust. We saw it work. It was just as smooth as can be. Save the sales pitch. We want one." Because we've seen it work. Yes, that's good. And it is. It can go that smooth if it's done right. Yeah. And so we concentrate on doing it right, because, how are you going to know it's done right? You're going to know after death, that's for sure. Yeah. And that's not the time you want to find out something's not right.
Well, I can tell you firsthand from dealing with families and dealing with auctions and estates and people dealing with estates, if things aren't clear and done right, it can cause such rips and such problems. And I see it a lot.
And that's not even counting the stress, the mental stress people go through. Yeah. I mean, I have people just, tears come to their eyes. It's like, is this ever going to end?
I had a friend who called me just within the last week, out of town, not here. But his family is basically falling apart. He was in tears because of having to deal with the family's properties, and the siblings are not getting along now. And he said, I would have never thought we'd been like we are.
And when I said earlier that I love what I do,
Yeah.
the only thing I can think of that I don't like about what I do is sometimes I see this ugliness that happens with families.
Yeah.
Had a gentleman yesterday said he had the not so good privilege to be executive of the estate of two people in the family.
Yeah.
He said one took forever, but it really wasn't too problematic.
Yeah.
Just took forever and all that. But the other one, he said, I think it was his brother. And he said, there are some nephews in there that just won't even speak to each other anymore.
Yeah.
And he said, and it was over the dad's shotgun.
Yeah.
I mean, I know it sounds to me like the shotgun was real important to them.
Yeah.
Okay, but still, I mean, that should not be a result, and I hate it when it is.
I do too.
But it happens.
I do too.
It happens a lot because, I would have said, all right,
Well,
if I was the executor of that will, I'd have said, okay, this shotgun, go get me a hacksaw, and I'm going to exercise the wisdom of Solomon.
Yes. Exactly. Well, and you hate to see it. And the emotions are high.
Yeah.
And feelings are there. And they're legitimate feelings. I mean, everybody has their feelings,
Sure.
and it's and something means something to somebody. But it could all be helped and avoided with planning from far in the past.
That's right. That's right.
And set up things like the want.
That's right, and that's a big difference. And people, you get somebody every now and then that says, "Well, I don't care. I'll be dead, and the kids can fight over it." I mean, if you don't care, then what we do in my office is not a fit for you.
And you might ought to say they will.
Yeah,
they will fight over it.
What we do is not a fit for you if you don't care. We deal with people that care about what's going to happen to their family after they're gone, and they want it to be as smooth as possible. And sometimes that's my marching order. Someone come in and say, "Listen, I want to do this. I just want everything to be as easy on my kids as possible." That's the marching order.
That's a great thing to be and think.
Yeah. And this is the game that's out there that is the easiest thing to do when it comes to descent and distribution of property after death.
Absolutely.
A trust of some sort, the revocable living trust, the asset protection trust, they put the property into the trust. The trust governs all that. It does it court free, adversarial process free. I mean, it is just a smooth procedure. It just goes along like. Just glides along. Every now and then we get a little chink, a little hiccup, but I mean that's usually to be expected.
Sure.
But it's nothing in comparison to the problems you run into in the probate courts. Right. And the probate courts are supposed to be like that. When I get down on the probate process, I'm not saying they do it wrong or it's a mess or it's negligence. No, that's the procedure. Yeah. That's what the procedure says to do.
Yeah.
And that's what makes it cumbersome.
Let's see if we have a question from one of our listeners out there. Good morning. You're on with us. Hello. Well, maybe he didn't want to be on, whoever that was.
But anyway, hey, it looks like we're kind of slowly winding down.
We are slowly winding down.
Hopefully, I don't know what the
range. It's been an interesting discussion, though, this morning. Really.
Yeah, it was good. I like it.
Yeah,
I love to hear
very
from
interesting.
People.
And of course, we got to hear from one of your clients. And that's always good. What we should do, though, while we got the remaining minutes, is remind folks where your office is, which you're over on the square in Pulaski.
I am right on the square. I'm on the southeast corner, right beside that big old Star Theater. That's right beside me, but I'm right on the corner there. It's 103 North First Street, but if you find the square, you will find me.
Yes, I know exactly where you are.
If you need to call and talk to me, my number is 931-363-7222. If you want to schedule a call, usually when people call and say, I need to talk to Stan, the gals will schedule a call back.
Yes.
And I like doing that. And I'm going to tell you why in the last minute or so. We call them 15-minute phone calls. I call them 15 lawyer minutes because you hardly ever get anything done in 15 minutes.
Right.
But you get the concept. What it is, if let's say a couple hours from now, I'm back to the office, and you call me and want to talk to me about something that's important going on in the family. Well, let's say non-emergency, but we don't have too many things in this area of the law that are emergency, but sometimes.
Yeah.
And you want to talk to me, the guy's going to say, well, he's doing something else. He's in a meeting.
Yeah.
He's on a Zoom meeting. He's talking with another client. He's working on, this is his drafting time, and or whatever. I'm doing something. I'm doing something every hour of the day, and they control my time. And I always like to say they jealously guard my time.
Yeah.
It's like a football game. You got to get past Alex, Courtney, and Tammy before you can get to me. Now, I don't say that because I don't want to talk to you. They just structure my time. So here's why these phone calls work so well. You call up and say, I want to talk to Stan. They'll just say, okay, give me the basic question. And they're not trying to be nosy. I've heard Alex say before, listen, I'm not trying to be nosy, but I know when I tell him to call you back, he's going to say, what's it about?
Regarding.
And the reason I do that is if you can give the basic question to me, give me a couple minutes to think about it so I can kind of get my brain into that mode.
Yes.
And now here's the thing. When I call you, so he'll call you this afternoon at 3:30.
Yeah.
At 3:30, and I try to be on time, it just depends, but I call him at 3:30. My attention is now with you and your question.
Yeah.
I'm not doing something else. You didn't drag me in the middle of, I'm not shifting gears mentally, which is harder and harder to do.
Right.
And so I'm prepared. That time is yours to talk to me about this question. And it works really well for me. I think it works well for people.
Sure.
Some people like to have it sooner, and it's usually the same day or maybe at the most next day.
Yeah.
We don't schedule phone calls a week out.
Yeah.
In-person meetings, my schedule does stay pretty, they are a week or 10 days or sometimes more out. But so if you want to call me, just call that number or email me and say you need to talk to me. I can usually answer emails pretty quick. But sometimes it's a long, involved answer. And,
sure.
I don't like to type that much, but I do.
I understand.
So if you have questions, by all means, I offer that time freely. Ask, and I'm more than happy to answer it. I just like to answer it in this structured mode that we do because it works well for me.
And don't forget the next seminar.
I don't multitask as well as my wife.
Yeah.
So if you call me and I'm in the middle of something, it takes me a while to get back to where I was.
I understand.
I'm one of those people that definitely gets in the zone when I'm doing something.
That's right.
Next seminar coming up, 2 weeks from yesterday, I suppose. October. Boy, I'm having trouble saying the word
October 19th,
I keep wanting to say August, but it's already October. October the 19th. Now, that's a Thursday. So we do that at 1 o'clock in the afternoon, 1 p.m., and that's going to be right next to my office at the Star Theater.
Yes,
so you come to that. Will's Trust in the Nursing Home is what we call it, and that's kind of what we're going to talk about. If you hadn't been to one of my live seminars, really, you ought to give it a try. So,
absolutely.
Pierchoski State Law, Pierchoski Elder Law, 931-363-7222, or go to estateplanstand.com, and that'll get you to my website.
That's right. Stan Pierchoski, everybody.
I'm staring at the clock behind you.
Yeah, we're gonna have to take
15 seconds.
Fox News break coming up here soon, but been an enjoyable visit today, and look forward to seeing you again next week, good Lord willing. Hope you have a great week, and we're going to get on out of here in just a couple of minutes. Again, that phone number, 931-363-7222. Estate Plan Stan, everybody. Thanks, buddy.
Thank you, Jeff.
See you later.
Broadcast services of Prospect Communications.